Picture this. You married your spouse 2 years ago. You did everything the right way. You filed your papers on time. You went to your biometrics appointment. You sat through your interview and answered every question honestly. You thought the hard part was over. Then one ordinary afternoon, you open your mailbox, and there it is. A letter from USCIS. Your hands are already shaking before you even open it, because deep down, you know this letter is not routine. You open it, and there are no soft words, no request for more documents, no second chance to explain anything. Just a short, cold sentence. Your I-751 has been denied. No RFE. No warning call. No meeting. Just denied. And in that moment, your entire future in this country suddenly feels like it is hanging by a thread. But here is what most people still do not realize. This letter is not the end of your case. In many situations, it is actually the beginning of something much more serious, something that can lead directly into removal proceedings in immigration court. Let's slow down, because this is the part most channels rush past, and it is the part that actually matters for your future. The I-751 is the form a conditional permanent resident files to remove the conditions on their green card. This applies to people who received their status through marriage less than 2 years before becoming a resident. USCIS wants solid proof that the marriage is real, ongoing, and not just a shortcut to a green card. Most people assume that if there is any weakness in their case, USCIS will send a request for evidence, giving them a chance to submit more documents and fix the problem. That is what usually happens. But it is not what always happens. In some cases, USCIS reviews the entire file, decides the evidence simply is not convincing enough, and denies the petition outright. No RFE. No additional opportunity. Just a denial. And for a conditional resident, this triggers something immediate. Your conditional status is terminated as of the date of that denial. Legally, from that point forward, you are no longer considered a lawful permanent resident. USCIS South does not simply close the file and let you walk away. In most of these situations, they issue what is called a notice to appear, which places you directly into removal proceedings before an immigration judge. This is where many people make a critical mistake. They assume the USCIS decision is final, that there is nothing left to do. That is simply not true. In reality, this is often just the beginning of a longer, more complicated legal process, one that now takes place in a courtroom instead of a USCIS office. So why does this matter so much for you, right now, today? Because once your case enters immigration court, everything changes. You are no longer just waiting on paperwork. You are now part of a formal legal proceeding. You will likely be required to appear in person before a judge. The burden of proving your marriage is genuine does not disappear, it simply moves to a new venue. In some ways, immigration court actually gives you a fresh opportunity to present your case, sometimes with more flexibility than USCIS allowed. But it also means higher stakes, stricter procedure, and far less room for mistakes. This is not just a suggestion. In many cases, it is federal law that once conditional status is terminated and a notice to appear is issued, the individual is placed into formal proceedings under the Immigration and Nationality Act. This is not something anyone should walk into unprepared. Now let's talk about the real risks, because this is where people get caught off guard the most. The first risk is time. Once a case reaches immigration court, the calendar can move slowly. Some cases take months. Others take much longer, depending heavily on the backlog in the local court. During all of that time, your legal status remains uncertain. Some individuals are permitted to remain in the U.S. with valid work authorization while their case continues. Others may not have that same protection, depending entirely on their specific circumstances. This uncertainty affects your ability to travel, to work, to make long-term plans, and honestly, it affects your peace of mind every single day that passes. The second risk is weak evidence. A huge number of people going through an I-751 denial originally submitted a thin evidence package. A handful of photos. One joint bank statement. Maybe a shared lease. USCIS officers review thousands of these petitions every year, and they are trained specifically to identify patterns that suggest a marriage may not be genuine. If your original evidence was weak, and you walk into court without dramatically strengthening it, you risk repeating the exact same mistake, except this time the consequences are far more serious. The third risk, and this one is constantly underestimated, is trying to face this alone. Immigration court is nothing like an interview room. There are formal legal standards, evidentiary rules, and strict procedural deadlines. Attempting to navigate removal proceedings without an experienced immigration attorney is one of the most common, and most costly, mistakes a person can make. This one decision, skipping proper legal representation, can quietly create serious, sometimes irreversible problems later, including your ability to remain in the country at all. So what can you actually do if you find yourself facing this exact situation? First, do not panic, and do not ignore the notice. A large number of people, overwhelmed by fear or confusion, delay responding or miss their scheduled court hearings entirely. Missing a court date can result in an automatic removal order issued in your absence, without you even being present to explain yourself. This is one of the most damaging outcomes possible, and it is completely avoidable. Second, rebuild your evidence immediately, and go far beyond the basics. Joint tax returns, insurance policies listing both spouses, photos taken across different years and different moments, sworn statements from people who genuinely know your relationship, and any documentation that shows a real, shared life rather than just a shared address. Your goal is to build a case so strong that a judge is left with no reasonable doubt about the relationship being real. Third, and this point cannot be repeated enough, speak with a qualified immigration attorney as soon as possible. This is absolutely not the moment to represent yourself, and it is definitely not the moment to rely on advice from social media or unlicensed consultants. Removal proceedings carry real legal consequences, and proper representation genuinely changes outcomes for a lot of people in this exact situation. Fourth, stay closely connected to your case. Check your status through official channels regularly, and if you move, update your address with the immigration court immediately. Missed mail and outdated addresses are responsible for far more removal orders than most people ever expect. Now let's bring all of this together quickly, because there is a lot to absorb here. An I-751 can be denied without ever receiving an RFE. When that happens to a conditional resident, it typically terminates their status immediately. That termination often leads directly to a notice to appear and placement into removal proceedings. Once your case is in immigration court, everything becomes more formal, more procedural, and far more serious. The major risks are long periods of uncertainty, reusing weak evidence without improving it, and attempting to navigate the courtroom alone. The protective steps are simple but powerful: respond immediately, strengthen your evidence significantly, hire an experienced immigration attorney, and stay fully engaged with every stage of your case. None of this is meant to frighten you. It is meant to prepare you. Thousands of people have gone through an I-751 denial and removal proceedings, and many of them have still been able to present a strong case and protect their future in this country. The real difference between a good outcome and a devastating one almost always comes down to one thing: how quickly a person understands what is actually happening, and how seriously they respond. If you, or someone close to you, is currently dealing with a conditional green card, an I-751 filing, or any uncertainty involving USCIS, do not wait for a denial letter to show up before you start preparing. Stay informed, and always verify details directly through official USCIS and Department of Justice sources, because immigration policies and procedures can change. If this video helped you understand what is really at stake here, share it right now with someone who might be facing this exact situation. They may not fully realize how serious it can become until it is already too late. And if you want clear, accurate, and genuinely practical guidance on real immigration issues like this one, subscribe to this channel today. We break down real cases and real policies so you can stay prepared, stay protected, and stay one step ahead, no matter what challenges come your way.